Hey everyone, I'm Jonathan Porter, and I'm hoping you can hear me. We've been having some technical issues, but hopefully you're hearing this just fine. I'm a partner here at Husch Blackwell in the Healthcare, Life Sciences, and Education group, and we appreciate you joining us today. Before we begin, the firm's webinar people have asked me to cover a few housekeeping items. At the bottom of your audience console that you're looking at, there are some application icons that you can use during today's program. If you have any questions during the webcast, you can submit those in the question box that you see. I'm going to try to save time at the end to answer your questions, but if I don't get to your question, I'm going to follow up with you. So please feel free to ask your questions as I go. Otherwise, you may forget your question at the end. So go ahead and ask them, but I'm going to wait and answer them at the end. We're also going to give you a PDF of the presentation. You can look at that now if you want to. It's in the program materials folder. This program has been approved for legal education hours. And to report those hours, you can click on I think it's CEU or CLE icon at the bottom of your screen. We're also going to send you a certificate of attendance, including the course number. We'll email that to you tomorrow, along with a recording of this webcast for watching and sharing if you want to. Last housekeeping item. Towards the end of this program, we're going to ask you to complete a short survey. We really do use those to plan future programs. We want these webinars to be sort of useful to you. So the more you tell us in these surveys, the better our programming will be. So you'll see the invitation for the survey at the end of today's webinar. So that's the housekeeping items. Let's get started. So you can see this on the screen, the topics that we'll be covering today. These are 7 of the many ways that academic medical centers can get in trouble with DOJ. These are not the only 7. If you decide to use your academic medical center to launder cartel funds or plot to overturn an election, you can very much get in trouble for that too. I've just picked 7 that have been an issue in the past and that I see as potential issues going forward. You've also got, as you can see on the screen, a bonus topic coming from an upcoming False Claims Act trial that not enough people are aware of, in my opinion. We'll get to that at the end of our time together today. But before we get started, let me tell you a little bit about the guy who you'll be listening to over the course of the next hour. For those logging in a minute or two late, I'm Jonathan Porter. I'm a partner at Husch Blackwell in the healthcare and white collar groups. I'm a former federal prosecutor. I'm one of the few former federal prosecutors who handled both criminal and civil healthcare fraud cases. Usually AUSAs handle one or the other, but I did both. Long story on how that came about that we don't have time for today. I'm happy to tell that story offline. But anyway, on the criminal side, I did a lot of the telehealth cases that you saw in the news: Operation Brace Yourself, Operation Double Helix, Operation Rubber Stamp. I was a part of all of those. Along with a large team at the Justice Department. I also tried the very first medical professional that was indicted as part of those telehealth fraud cases. But I also had a heavy civil load as well. I investigated and litigated a range of cases under the False Claims Act, settled a lot as well. So now that I'm in private practice, I've been in private practice since the beginning of this year, and my practice is to help healthcare providers with federal investigations and compliance issues. And also make it a point to keep up with, emerging issues, like late-breaking DOJ action. And so I think I'm hopefully going to get you some useful, practical, up-to-the-moment information on what DOJ is doing in this space. I'm based in Georgia, but I have a national practice. I have clients coast to coast. I also teach law as an adjunct professor at Mercer University School of Law, Go Bears, in Macon, Georgia. I teach a class there on white-collar crime. So that's who I am. That's where we're going today. Let's get started. But before we talk about the 7 ways to get on DOJ's radar, I want to spend a minute explaining how DOJ's radar works in the first place. I'm sure you've all heard about DOJ's investment into sophisticated tools to discern from Medicare data where fraud is occurring. I can tell you those tools are being utilized. As a former AUSA, I can tell you without question that those tools really are helpful to DOJ in identifying potential bad actors in the healthcare field. But the data actually tells a different story, and that's what I want to point out. So every year, DOJ puts out metrics on the cases that DOJ civil frauds opens, and resolves. And what's interesting about this year's data is that the fraud section resolved $2.2 billion worth of cases in fiscal year 2022. Of that $2.2 billion, $1.9 billion was in qui tams. And amazingly, of that 1.9 billion, around 1.2 billion was in declined qui tams. What does that mean? That means 89% of dollars collected by DOJ civil frauds last year was started by whistleblowers. Whistleblowers are driving DOJ's radar. Despite all the resources being pumped into healthcare data analysis, it's still whistleblowers running the show. So whistleblowers settled or received judgment even more than DOJ did last year. And so when we talk about DOJ's radar, we're really talking about what whistleblowers are bringing to the Justice Department. That's the not so hidden fact in what it is that I do. Whistleblowers are setting DOJ's priorities for them when it comes to civil enforcement over the healthcare field. So it's not data, it's whistleblowers, relators. That's how DOJ's radar works. So when we're talking about today, it's not just what DOJ has been investigating and will continue to investigate, but also what cases the whistleblower bar is seeking out. Because I know for a fact that sophisticated attorneys who represent whistleblowers are seeking out clients with particularized knowledge for particularized issues, for particularized deep-pocketed health systems, especially ones that want to be seen as above board, like academic medical centers. That's why we're talking about these today. So all that being said, what are the theories that whistleblowers are causing to be put on DOJ's radar? We're going to start with AI and auto ordering. In 2009, there's a book that came out called The Checklist Manifesto by this excellent author, Dr. Atul Gawande. The book's point was that a significant number of errors in medicine could be fixed by checklists. AI is the future. There's a lot of way to integrate AI to improve the delivery of healthcare, including by, building checklists that are interactive and that change based on patient conditions. There's so much ability in this space. I think we all recognize that. But it's not just like checklist type stuff. There was a recent study from a few months back that's on the screen now that shows that AI can actually improve medicine through more than just directing treatment. The Journal of American Medical Association published this article on ChatGPT, actually besting real physicians on empathy and bedside manner. Going beyond that, Google thinks they've figured out how to take that, one step further. MedPalm 2, which I think a lot of you have heard about, this is a major advancement in the field of healthcare. It's already been proved to blow away the U.S. medical licensing examination and score on, expert levels on every, board. But and Google thinks that they could turn this into a system that integrates with what health systems do every day and to enhance the practice of medicine. Google envisions MedPalm 2 as, analyzing prior medical records faster, looking at imaging, tests, labs better than specialists. And so if AI is able to diagnose better, treat better, communicate better than physicians, that's really something that we should be thinking about. There's definitely a need to integrate AI into the practice of medicine, just like the law. But there are bound to be some growing pains, at least while Medicare and other payers consider how AI impacts what they're willing to pay for. The baseline concern for us here is that Medicare's age-old test for coverage is medical necessity. I fear that as AI is used to increasingly determine when tests, labs, referrals should be made, whistleblowers are going to say that those actions violate medical necessity because physicians aren't actually making individualized determination of that medical necessity. That's a general fear I have, but that's a gray area fear. There are actually some real areas where it's not even gray, but it's black and white per Medicare regs. One of those areas is diagnostic testing. The reg on the screen, it's pretty clear that diagnostic tests must be ordered by the treating physician, and that tests not ordered by the treating physician are, by definition, not reasonable and necessary, and thus not covered by Medicare. Our friends at the University of Miami, they were early on trying to incorporate AI or auto ordering into their system for practicing medicine, only to see a whistleblower file a qui tam, alleging that their protocols were that the protocols for automatically ordering diagnostic tests in certain medical situations violated Medicare's regulation that said that those diagnostic tests must be ordered by a treating physician. Now, I would imagine that the attorneys for the university argued that when the treating physicians approve of these protocols for situations, that they've really just pre-certified medical necessity. But ultimately, the university opted against testing that before jury, and instead they settled for $22 million. DOJ's press release specifically mentions that the practice of using a preset protocol for running tests as a basis, that was their basis for the false claims to Medicare. So what do we learn from this? As we're implementing AI-like technology into our systems to improve medicine and patient outcomes, we lawyers have to keep an eye on the regulations. Again, I have a fear that at some point, some health system is going to be arguing to a jury that AI can adequately ensure medical necessity without a physician literally clicking approve. But until then, we should at least know what regulations require literal physician approval every time. Diagnostic tests are one, but I'm sure there are many, many more. And so what we're going to do is offer you a takeaway for each one of these seven. And our first takeaway is that as we're implementing processes, and I'm sure a lot of your leadership are thinking about how to implement AI, as you're implementing processes that in any way involve AI or automatically ordering or referring, we've got to be mindful of regulations that require physician involvement. Our friends in Miami won't be the last health system to get ahead of Medicare on implementing technology. And budding whistleblowers within your health system are watching how you're implementing these AI processes. So that's our first takeaway. Number two, our next topic is misusing tracking technologies. This is one that is really heating up. Tracking technologies have been around for many years. I'm sure AOL used cookies back in the dial-up modem days to see which GeoCities pages you were clicking on from your Alta Vista search engine, but tracking engines have advanced a lot in recent years. The tracking technology we're talking about today are Metapixel and Google Analytics, which are insanely good at tracking everything that all of us are doing online and using their knowledge to put the right ads right in front of your face at all times. When you Google something, all of a sudden you see ads, that's not a coincidence. This is, however, a problem when we get into the world of protected health information. This alarm was sounded in 2020 in a Consumer Reports article that talked about this website called GoodRx. And saying that GoodRx was sharing data with Facebook and Google. GoogleRx advertises a lot. You may recognize the name. They essentially promise that you can go to their website, put in whatever drug you want to buy, and it'll price compare for you and offer you discounts, coupons, those sorts of things. That very business model involves searching for specific medications because apparently there's a huge variance in the cost of prescription drugs from pharmacy to pharmacy, and it fluctuates from drug to drug. Why that is, I will never understand. It's not my area of expertise. But anyway, according to Consumer Reports, GoodRx was capturing a lot of data from people who used their service, and that data included medications searched for, along with enough information about the individual to actually identify them. And according to Consumer Reports, GoodRx was then sharing a bunch of that data, including medication search with Google, Facebook, and others. That's a big problem for GoodRx and a really big problem for all of us. This issue is now squarely on the radar of DOJ, FTC, HHS Office of Civil Rights. And of course, health systems are now using more and more technology to reach patients. Using more and more technology to make their medicine, to make the practice of medicine easier on patients, more accessible. So the vulnerabilities are just out there. Just looking at recently disclosed data breaches, you could see what health systems are struggling with as they integrate mediums accessible to patients on platforms that patients are used to using, like Facebook and Google. These are good ideas, but there are growing pains here. These are not health systems that are greedily looking to make extra cash by knowingly selling patient data. This is happening because we don't have the right handles on the platforms that we're using. That means that we're potentially disclosing to third parties things like the types of appointments or procedures that patients are coming in for, along with their names and medical record numbers, insurance information. these disclosures are coming quicker and quicker. It's not just Romanian hackers. We're doing a lot of this just on accident. And the feds are responding. 9 months ago, HHS OCR put out a bulletin warning specifically about Google Analytics and Metapixel. The feds don't name names very often. When I was a federal prosecutor, my indictments read like the ones you've seen on the news lately with, Company 1 and Company, Conspirator 12. OCR, they actually named names. They put out a bulletin specifically naming Google Analytics and Metapixel. And they're following up on it. So last month, OCR and FTC sent letters to 130 hospital systems and telehealth providers that warned them about their integrations involving Google Analytics and Metapixel. And then they put out a press release announcing that the letters were sent out. Not sure you need a press release to announce letters, but I think it's clear that they're serious. And this issue is getting larger and larger every day. Just last week, in response to Google MedPalm 2, which I mentioned a few minutes ago, Senator Mark Warren of Virginia publicized a letter that he sent to Google objecting to the testing of MedPalm 2 in health systems because of data privacy concerns. It's ironic to me that health systems are in trouble with FTC and HHS over sharing data with an arm of Google, and now another arm of Google is trying to get us to let them be even more embedded in their healthcare. But these questions are only going to get more complex from here. And so our second takeaway today is that you've got to get a handle on what integrations your tech has. Find out what's being tracked and what's being shared with third parties, with vendors. I guarantee you that you'll see something splashy from DOJ on something like this in the coming years, or some story in the media about some patient's data getting shared with the wrong company and a health system is to blame. You can't stop every bored CNA from doing something ridiculous on TikTok while in a patient's room, but you can get a handle on tech issues like these before FTC and DOJ finds out about it. So that's our second takeaway. Our third issue is concurrent surgeries. This could be its own hour-long program to dig into what's allowed and what's not, but we're only going to cover enough for you to go back and ask some questions about processes. But this has been a problem for systems in the past, and it's going to continue to be a problem going forward. So concurrent surgeries are different from overlapping surgeries. Medicare is good with overlapping surgeries. There's all sorts of time during surgeries that's not critical, unless you're the patient, and then you're probably consider the whole thing pretty darn critical. But there's stuff that teaching physicians need to be there for, and there's stuff that they don't need to be there for. Teaching physicians can duck out of one surgery during non-critical periods so long as they're available to immediately return. That's overlapping, and that's fine, at least according to Medicare. But expert surgeons always think they can handle more than that. That's takeaway number 3. Surgeons think they can handle anything. No, that's not takeaway number 3. Just kidding. So what they can do is lead to whistleblowers alleging fraud. Here's one on the screen now is one instance of that when the United States intervened in this qui tam alleging that the University of Pittsburgh Medical Center had a surgeon who was violating Medicare rules against concurrent surgeries. And the thing about surgeries is that they're often charted pretty comprehensively, which means lining up concurrent surgeries is pretty easy for DOJ, as they did here, and included in their federal complaint alleging violations of the False Claims Act. DOJ noted that the overlapping requirements say you must be immediately available to return to surgery, which is hard when you're 2 miles away in a different surgery. In other examples in this complaint, the Justice Department showed that 3 surgeries were going on at the same time. That exceeds the definition of allowable overlapping surgeries. And let me just pause here to say, there's a factor that's greatly discussed within DOJ healthcare world that isn't often known outside, and that's the who cares factor. There are tons of health systems violating technical rules that no one really cares about. The who cares factor is a mainstay in every False Claims Act discussion, at least within DOJ. Who cares if a world-class surgeon is in the OR next door during an arguably critical time in the surgery? So DOJ tackled the who cares problem head on with allegations in their complaint that that said that these weren't just medically unnecessary, but that they also contain patient harm. These anesthesia billings could lead to patient harm. So DOJ pairing up technical shortcomings with patient harm, that's a big problem for health systems. And there have been a lot of studies on this issue, at least in the world of the, by the book compliant overlapping surgeries. There's a study, again, in the Journal of the American Medical Association a few years back that found no increased mortality or post-op complications for patients in overlapping surgery, but there was a statistical significance for increased surgery length. And the article found that to be a potentially troubling result for a lot of reasons. And so concurrent surgeries have an element of patient harm that everyone should watch out for. But besides the who cares factor in this one particular case we're looking at with Pittsburgh, there's another aspect of the case worth pointing out, and that's that your policies can and will be held against you. As you can see on the screen, UPMC's policy goes beyond what Medicare requires in its overlapping surgery guidance. It says that it doesn't allow teaching surgeons to perform another procedure while during non-critical portions of the surgery. So policies are a huge double-edged sword in DOJ world. If you don't have a policy, DOJ is going to allege reckless disregard to prove knowledge. If you do, that's your knowledge. And while a policy can't change Medicare guidance, you better believe a judge is going to view gray area disputes differently if your own policies show you believed the opposite of the dispute. That's in part the problem in super value that the Supreme Court just decided. So in the end, UPMC settled with DOJ, agreed to pay $8.5 million and to implement a monitor. Monitors are super fun for health systems, right? But there's a lot of gray areas in what crosses the line from permissible overlapping surgeries to impermissible ones. And I think you're going to see considerable pushback in the coming years on qui tams alleging fraud in this space. And you're actually already seeing it. So this was on the screen now as a headline from Law 360 a month or two ago. The health system moved to dismiss a qui tam with what I think is the correct argument, that the qui tam didn't properly allege the line between permissible overlapping surgeries and impermissible ones. Here's the critical language from the motion to dismiss, noting that you can't just put up timestamps and say it's wrong. You've got to know what parts were key and critical. That's the reg, key and critical. And I think it's on the whistleblowers to adequately allege that. So I'm hopeful that the health system in this case is going to prevail. I'd certainly make the same argument if it were my case. But that leads to our takeaway number 3. With this hotly disputed issue, you got to check your overlapping surgery policy. You got to make sure your surgeons understand the key and critical portion, and maybe think about how they're documenting that key and critical portion to avoid qui tams going forward. Because I can tell you that DOJ loathes the idea of second-guessing medical decision makers, but they love the straightforward cases based on time. When I was at DOJ, I had several successful False Claims Act settlements based on time codes. Psychotherapy, prolonged service codes, those are easy to second guess because you're looking at the start and stop times in the charts. Concurrent surgeries, these are similar. So think about advising your surgeons to include in their notes when the key and critical portions start and stop to avoid second guessing by whistleblowers. Next, we have research misconduct. For those who looked ahead of the agenda and saw grant fraud coming after this, you're right that most research misconduct is a DOJ problem in the context of grants. I'm scoping these two categories as separate. We'll look at research misconduct here and then other types of grant fraud next. But that's why you're seeing both research misconduct and grant fraud. So research misconduct is especially important for this group because it's your institutions receiving the bulk of the grants to fund research. And it's a lot of money being awarded for research. This is just NIH's budget for extramural research awards every year. But there are many other sources of federal funds for research. And my pea brain can't comprehend numbers above a certain amount. So I personally find it helpful to put big numbers into context. So I've provided some comparisons so you can realize how much NIH is awarding each year. NIH is giving away the entire economy of Libya each year. NIH gives grants that exceed NASA's entire yearly budget. We're talking huge dollars. And really giving grants is what NIH exists for. And it's spread around to a lot of different institutions. But we all know that academic researchers in the healthcare space are getting a really significant amount of these funds. So this is a topic that we should be aware of, that this group should be aware of, because where dollars go, whistleblowers will follow. And while a lot of research happens in this black box away from the public's peering eyes, big recent settlements are changing incentives for people to come forward and blow the whistle on research misconduct. We'll talk about those in a minute. But first, let's get a handle on exactly what we're talking about when we discuss research misconduct. The definition is on the screen, but it's essentially faking something, faking the research, faking the resulting conclusions of the research. If you falsify or fabricate the research, that's misconduct. Along with plagiarism, which might be the next big frontier on research misconduct, given how apparently prevalent it is in the research community. But now's a good time to mention that it's important to keep materiality in mind when we're talking about something as amorphous as research misconduct. We're going to talk about a case that was black and white in a second, but the majority of the issues in research misconduct will be gray areas. And that's when we should think about materiality. And Escobar is still the controlling law on materiality. What's material? The Supreme Court in Escobar said that it's not about what the regulations say, but whether it affects the government's payment decision. Senator Grassley has an amendment to the False Claims Act that might change that, but for now, Escobar is still controlling. That's what materiality is. That's hugely important in research misconduct because factual questions on what crosses the line into misconduct abound. If you get a report up through the compliance chain saying a researcher is doing something wrong, how do you evaluate that? Is this something that goes to the heart of what NIH is funding? Is it gray area? It's critical to keep materiality here in mind and to have that focus of the internal investigation that you'll hopefully call me to help you with if you like. So because the case we're talking about today is as our example of research misconduct came about when the whistleblower spent years trying to get the attention of people at the university to the misconduct only to be ignored. And so like a little mini takeaway at this point is that when you ignore accusations and don't at least give the accuser the appearance of taking it seriously through an internal investigation run by serious people, they're way more likely to file a key tam. Keep that in mind. That's just a fact. And that's what happened to our friends at Duke University and the Duke University health system. This is an important case that I'm sure everyone remembers from a few years back, but I want to spend a few minutes laying out the cast of characters so we all know exactly what went wrong at Duke. Erin Potts-Kant, she was a researcher in the lab of Dr. William Foster, who was an accomplished scientist in the field of pulmonology. The work done in that lab was very difficult. So they were measuring mice responses to inhaled substances. Tiny mice, tiny responses needed to be measured. And Erin Potts-Kant apparently had a knack for getting these impossible measurements. And those measurements always affirmed what Dr. Foster was hoping the data would show. And so he became very protective of Ms. Potts-Kant because she was helping this research. So he promoted Ms. Potts-Kant, included her on his research papers, and defended her when she needed defending. But Dr. Foster's pulmonology lab was active and had other people, including a man named Joe Thomas. Joe's job was to run similar tests to those being performed by Ms. Potts-Kant. And Joe had been around long enough to immediately spot that there was something wrong with what Ms. Potts-Kant was doing. The numbers were too good, and she had unusually low error rates, given that she was testing, pulmonology responses in tiny creatures. And so Joe started sounding the alarm to Dr. Foster and to others at the university. But Dr. Foster, he was a top researcher. He protected Erin Potts-Kant because she was getting results that Dr. Foster liked. And then other Duke researchers heard about how Erin Potts-Kant was able to get results like others could not. And she started partnering with other labs on difficult research. And she earned more and more protectors against accusations coming from people like Joe Thomas. And so Joe Thomas's alarm bells were ignored for over a year until Ms. Potts-Kant was was caught embezzling funds, and she was fired. But it was too late, because that same year, 2013, Joe Thomas filed a qui tam alleging that nearly every experiment or project Aaron Potts-Kant did at Duke was fake. And he had details, specific tests, instances where she made up data without running a test. Other times when she reported results that she'd changed. And Joe Thomas told how she did it: downloading source data, importing it into Excel, and then altering the data. But this is hard to investigate, and courts aren't always understanding of how hard complex fraud investigations are. And so the court cuts short DOJ's intervention election period. They make Duke litigate against the whistleblower Joe Thomas for 4 years. During that time, DOJ, HHS, EPA, they're continuing to coordinate, they're continuing to investigate, they're digging into the raw data, the metadata, trying to verify what Joe Thomas was alleging. And in 2019 is when everything comes together on the Fed side. What typically happens in cases like this is DOJ creates a presentation, sometimes we call it a reverse proffer, sits down with the decision makers on the other side and previews what their findings were and what will happen next. And I'm guessing DOJ previewed the early results of an HHS deep dive and showed that they were going to seek intervention in this case for good cause based on their substantiation of Joe Thomas's claims showing massive fraud by Aaron Potts-Kant. Those findings were apparently convincing to Duke, and they settled. Big settlement, as you can see on the screen. And that's because grant dollars, I mean, these grant funds for research, these are big dollars. This is why you've got to keep tabs on research and take reports of misconduct seriously. This was hugely embarrassing for Duke. Ms. Potts-Kant, for her end, later that year, agreed to permanent exclusion by HHS, so she'll never work in a federally funded research program again. Because a few months later in 2019, HHS, they released their full findings of this investigation, showing 117 specific instances of false or fabricated data by Ms. Potts-Kant that appeared in 32 different published papers. Joe Thomas, by the way, was awarded the maximum relator share by DOJ, 30%. He earned over $33 million for filing the qui tam. And right then, I promise you, the whistleblower bar started seeking the next Duke University, and they're still working on it. At DOJ, I became friends with some very good, prominent whistleblower attorneys, and I know that this is something that's very much on their radar. And so our fourth takeaway today is that you're responsible for your Aaron Potts-Kanses, and you're responsible for your Dr. Foster labs. You're responsible for these grants. It's your reputation that will get wrecked along with theirs. The dollars aren't even the biggest consequence. It's the reputation. It's researchers trying to select which place to go to. It's our job to protect our institutional reputations by taking seriously and investigating seriously these accusations of research misconduct. If we don't, the consequences are going to be tremendous. But you also need to make sure that you're focusing on the right arguments to DOJ here, because right now you're far more likely to see one of your researchers cross a plagiarism line than a totally faked stuff line. And that's where you want someone savvy enough who can wade into the sea of materiality within DOJ world. DOJ is making calls on what types of cases they think are material and what aren't. And you'll never hear about the ones that they think are not material. So it takes someone with inside knowledge to get to, an apples to apples comparison using stuff, known to DOJ. That's critical with plagiarism because, as you'll recall in our slide defining research misconduct, plagiarism is by definition research misconduct. Does that mean it's material? Absolutely not. But those are the types of cases you'll want someone very experienced in this area to handle. But there are other types of grant fraud to be aware of besides research misconduct, and we will turn to those right now. The big one is claiming non-eligible costs to the grantor. And those lead to some occasionally ridiculous and embarrassing headlines like this one from earlier this year. There's something about this headline that tickles me. Scuba'd is a good verb. But the backstory is far more important than the headline. This again started with a whistleblower, totally on brand for today's presentation, right? So a qui tam which DOJ intervened in stating that this professor used NIH funds intended for HIV research, not for a logistical site visit, as he claimed, but instead as the professor's 50th birthday with friends. Most of the friends had no relation to any academic work. The professor is, acknowledged in personal documents that this was really just a birthday trip. This is just one of many examples using improperly using grant funds, but bad on the professor. But why should you care about this? Why should universities care about this? Because, as we talked about in the research misconduct section, your organization is on the hook for safeguarding these grants. So it's the university, as you can see on the screen, that ends up paying up in the ensuing False Claims Act settlement and getting the bad press when professors do dumb things with grant funds. Problems claiming costs to grantors, it's not just for scubaing either, it's also for claiming mundane costs like, salaries, administrative costs that ought not be claimed. Not as embarrassing as scuba trips, but I'm sure your organization doesn't want to pay $19.875 million either. Another big one that was catching a lot of traction in the Trump administration was undisclosed ties to foreign governments. DOJ, I think they had China back in mind back then, but it wouldn't surprise me at all if those same theories are being used to look at ties to Russia now. You guys may have read about some of the cases in this area in the news. Researchers with ties to China were investigated. Many were indicted. Some very wrongfully indicted, but others were rightfully indicted. But when those professors are applying for grants from NIH and others, they're making certain representations about ties to foreign governments. And omissions in that area could be a very big problem, not just for the researcher, but also for the university. Here on the screen, you see a press release from 10 months ago where Ohio State had to settle False Claims Act allegations on this topic. And so our fifth takeaway is to get a handle on what obligations you have in your grants and have a system to ensure compliance. I'd be very careful right now if you have research that in any way involves people in Russia, federal money flowing to anyone in Russia to perform research. So make sure your people know about that and have a system for stuff like that to be fed up through the compliance chain so you can catch problems before key TAMs are filed. All right, moving on. Our sixth topic is problems with the Provider Relief Fund, which I'll shorten to PRF. And while we've talked a lot about whistleblowers already today, I haven't given you my rule of thumb on whistleblowers, so let's do that now. My rule of thumb is that anytime Congress appropriates billions of dollars and invites companies to apply for funds based on inadequately defined terms, there will be key TAMs. That's not even a rule of thumb. That's more like a law, like gravity. It's going to happen. And if you thought NIH's $38 billion a year was a lot, you're going to be wowed by this one. So Congress appropriated $178 billion to healthcare providers in various forms and fashions to deal with COVID-19. That's a lot of money. That's what Homeland Security spends in a year. That's also double what DOJ spends in a year. That's a lot of money. And sticking with our rule of thumb, Congress provided almost no directives on how HHS was to divvy out this Homeland Security level amount of funds. It just went to HHS with the charge of figuring it all out. That's not a criticism of Congress. Getting funds out the door was the way to prevent total and epic economic collapse in the early days of COVID. So that's what they had to do, and they did it. So the money was just sent to HHS, and HHS pushed this down to good old HRSA. And HRSA came up with a plan to administer these funds in a variety of ways. A lot of the funds went out evenly as general distributions based on prior year's numbers, but there were a few ways where healthcare providers had to apply for funds based on representations made in applications. Let me just say, HRSA didn't do a bad job here. As a federal prosecutor during COVID, I was put on double duty to not just prosecute healthcare fraud, but also COVID fraud during the pandemic. I'll tell you that compared to SBA, HRSA actually did really well. I worked with SBA before the pandemic on fraud cases, and let me just say that SBA performed as well as I expected SBA to perform when given more money to distribute. So I'm not judging HRSA here too harshly. Draw whatever other conclusions you will from that last statement. But HRSA did get taken for a ride in some fairly obvious ways that, of course, no one's health system on this webinar would have done. One example is a nurse practitioner in Louisiana who owned a medical clinic. On her clinic's PRF Phase 1B application, she listed the clinic's 2018 revenue as $530,000, and she provided a tax return to prove it. But then, on her clinic's Phase 2 application for the exact same year, she reported that her clinic had revenue of $39.6 million. And here's why I'll ding HRSA a little bit here. Apparently, this NP then uploaded the clinic's real tax returns in the Phase 2 application showing $530,000 in revenue. But it seems that no one actually looked at the attachment. And therefore, HRSA gave the clinic around $1 million based on the $39.6 million number. That's stuff that SBA did a lot that drove me crazy at DOJ. There were plenty of people who faked tax documents that I prosecuted. I indicted a couple of lawyers for faking tax documents and sending them to SBA in support of large COVID loans. A pastor, too. That was a fun one. But it was infuriating when we'd be investigating and then we saw that SBA gave out a ton of money that could have been prevented by someone just opening up an attachment. Apparently that didn't happen here. And so the MP then went on a wild spending spree with the clinic's cash. She bought a Range Rover, a boat, property, all the usual stuff that makes judges and juries want to throw things at defendants. Side note, that pastor that I prosecuted, the first thing he bought was a Mercedes. I have another case where it made some news where the defendant used the proceeds of COVID fraud to buy a single Pokemon card, which he bought for $57,000. Yeah, that one caught the media's attention. If you're going to commit fraud, buying extravagant stuff is not a good move. Like what this Louisiana nurse practitioner did with her PRF fraudulent proceeds. So you've got egregious fraud that I'm sure doesn't apply to anyone tuned into this webinar. But for every clear black and white case, you're going to see 10 or more gray area cases because with our rule of thumb, here come the key terms. And one of the areas we're starting to see action is in the targeted distributions for high impact facilities. And if you read HRSA's descriptions on how these funds are supposed to have been distributed, you'll see that health systems have applied on COVID-19 admission numbers. But after having read everything publicly available by HRSA on what a COVID-19 admission is, I can't tell you what qualifies and what doesn't. I even pulled the terms and conditions for PRF high impact payments, which no one does. And even there, it's not clear what a COVID-19 admission exactly is. At one point, there's reference to providers diagnosing, testing, and caring for individuals with possible or actual cases of COVID-19. And at another point, it states that providers had to truthfully supply admissions data without saying exactly what it means to be admitted for COVID-19. But that didn't stop whistleblowers from claiming that these definitions were clear and that they required a positive COVID-19 test to be an eligible COVID-19 admission for PRF purposes. And this summer, we saw the very first PRF key tam unsealed. This key tam alleged that the defendant health system had patients that physicians had diagnosed with COVID, but didn't have a positive test for COVID, and that the health system reported the higher diagnosis number to HRSA instead of the confirmed positive number. The whistleblower himself stated that he alerted the health system that the correct number of eligible admissions to report was the number of those actually testing positive for COVID. The newly unsealed key tam contained a second theory, too, that we should talk about. So that theory, this second theory, which is on the screen now, was a misuse of funds. Apparently, the health system in question used PRF dollars to renovate a lobby and a building and to create a new innovation center and some other things. Now, if you read the terms and conditions for this particular targeted high impact distribution, which I did, it says that you can only use these funds to prevent, prepare for, and respond to coronavirus. So that seems like a facially valid theory, right? But the terms also has language about the payment reimbursing the recipient for lost revenue attributable to coronavirus. Do you have to comply with both use and loss, one or the other? That's not clear from this definition, of course. So I would think that if you've lost revenue attributable to COVID, then using PRF dollars on lobby renovations, it could be okay, or at least not fraud. And so, and by the way, that's important, at least not fraud. DOJ was fairly quick to decline intervention in this key TAM, and the case got unsealed. We don't know exactly why DOJ declined. DOJ doesn't give their legal theories in these declinations, but unless there's some extra definition of COVID-19 admission within the application portal that isn't publicly available, I'd say the DOJ declined because the term COVID-19 admission isn't sufficiently defined to constitute fraud, with one interpretation versus the other. So this is just one example of one type of PRF distribution, but I'm very sure that there are many others with different issues. So our takeaway is that these PRF key TAMs, they're coming. Know what you put in your application and be able to account for how you spend your funds. All right, finally, our seventh topic, this also involves our friends at HRSA, the uninsured claims program. So Congress feared that COVID would be catastrophic to uninsured Americans. And so the taxpayers picked up the bill for testing, treating, and vaccinating those who were uninsured. This was just for COVID. So HRSA wasn't picking up the tabs for toenail debridements for uninsured people during COVID. Testing for COVID, treating COVID, vaccinating against COVID. That's the list. By the way, $4 billion is nothing to sneeze at. Don't get spoiled by our PRF slide and the NIH slide from a few minutes ago. $4 billion, it's still a lot of money. Now, the issue is that the federal government doesn't have a database with a list of every American and their health insurance status. So how do they go about verifying uninsured status? That's a tough problem. And added to this challenge is that HRSA decided not to require patients to give their social security number to their provider as a condition of being, tested, treated, or vaccinated. So creating a system like this involves HRSA heavily relying on providers to be truthful in their efforts to verify uninsured status. And spoiler alert, providers aren't all truthful. On the screen now, you'll see an indictment against a physician named Dr. Haldane of California, who was the second highest recipient of uninsured claims funds at $230 million. That seems like a lot to me. That's like 5% of the $4 billion appropriation number, right? That's insane. And the criminal complaint, and by the way, from my review of the docket, this is still under seal. I'm getting this from DOJ's press release announcing the arrest of the physician. So that's where I'm getting this information. The criminal complaint authorizing the arrest apparently alleges that Dr. Haldane spent $100 million of these payments for uninsured treatment on high-risk trading options. Because if you're going to get $230 million in fraudulent proceeds, why not try to turn that into $500 million? You're going to need a good lawyer with that delta. So, but the HRSA uninsured claims problem we should be aware of is not just for the shady doctors, but for everyone who submitted these claims. So last month, HHS put out a report on your screen following their deep dive into the uninsured program. And they found an error rate of 19%, meaning that close to $1 billion was misspent here if we're going to extrapolate that out. They found that patients were either actually insured or being treated for something unrelated to COVID. So key TAMs will follow this report released last month. If you submitted claims for COVID testing, treating, vaccinating for uninsured people, make sure that you've got their uninsured status documented. Be ready to explain how you took steps to verify that status. And ideally, your physicians documented your COVID-19 hook in the charts when they accessed these funds. So those are coming your way. So now we've got a final bonus topic that isn't really a way to currently get on DOJ's radar because it's still in test phase, but it's something that you should very much be paying attention to because it's coming to a head later this year. Value-based compensation makes perfect sense to most everyone in healthcare. You get paid for value you create, right? Well, a group of whistleblowers in Pittsburgh seem to disagree with that model. The University of Pittsburgh Medical Center compensates based on wRVUs. You have to hit a minimum amount, and then over that amount, you get a certain number of dollars per wRVU. So according to whistleblowers, paying dollars per wRVU violates Stark because it varies with or takes into account their referrals to UPMC. Think about that for a second. Compensation that fluctuates with productivity is also alleged to compensate for referrals. How is that? The answer is that according to the relators, the dollars per wRVU, it equates to more than what UPMC makes from payers per wRVU. So they're losing money on these neurosurgeries, according to the whistleblowers. Why would they do that? Because they're valuing the extra services the health system gets to do these surgeries for these patients, and they're rewarding surgeons with extra money, according to the whistleblowers. Now, I have a suspicion that a lot of academic medical centers are doing exactly what UPMC does. And to my knowledge, it's never been a problem before, but it might be now. This particular case has a long history, as so much modern litigation does. It was partially settled, and then DOJ declined as to the rest. But the whistleblowers are carrying the non-settled allegations to trial after 2 dismissals, one of which was overturned by the Third Circuit, to make sure that So now trial is on for November of this year. I checked the docket a few hours ago just to make sure I was still current in this, and for my docket check, the trial is still on for November. In this case, if this is at all relevant to you, the Third Circuit's opinion is worth knowing. It essentially says that by performing surgeries at a hospital, the surgeon is referring to the hospital because there's all this other stuff that the hospital gets to pay for, or gets to bill for. So even though UPMC is paying value-based compensation, there are referrals baked in. How you unwind that, I have no idea. I suspect that this theory is such a stretch that DOJ doesn't want to touch it right now. This is why the whistleblower is taking the case to trial instead of DOJ. But the logistics here are an absolute disaster for the trial court. On the screen now is just one of the many disputes that the parties have on jury instructions. This one seeks to instruct the jury on what indirect compensation agreements violate Stark and which ones don't. I mean, wow. The parties, they were also required to come up with this case is crazy. The parties were also instructed to come up with a joint jury verdict form, which is what the jury fills out after they've deliberated. And they disagreed as to that so much, they just told the court they couldn't do it. How you're supposed to explain Stark to a jury is beyond me. I had a criminal healthcare fraud trial when I was at DOJ last year, and I was able to effectively explain the anti-kickback statute, but Stark is a different beast. This case is worth watching. Again, it's not DOJ's theory, but that may not matter. Add in civil penalties per Stark-tainted claim after trial, and the federal government and the whistleblowers may end up being partners in this academic medical center after this. The judgment would be unreal. And if it works, here come whistleblowers. The appeals will be worth watching too. The Third Circuit's made its peace, and the Supreme Court denied cert. So I plan on following this case closely. I'll likely write an article about it before it goes to trial in the next couple months. If you'd like to get updates, shoot me an email when this is done, and I'll gladly send you updates on the case. How do you send me an email? Great question. Through the email listed here. I'd love to hear from you. If you have any questions about anything we've covered here today, please really do reach out. I'd love to schedule a time for us to chat more in depth about anything. And then one more thing, as a secret double bonus, if your health system has its own managed care plan, you've got one more way to get on DOJ's radar. So DOJ, they're remaining active in investigating provider-owned managed care plans. Just 2 weeks ago, DOJ announced a $22 million settlement with a large New England provider-owned managed care plan. That enforcement area is super hot right now. If your health system has its own managed care plan, I'm going to put out an article later this week on that settlement and what DOJ is looking at when it comes to managed care plans. Again, if your health system has its own managed care plan, shoot me a note after this. I'll send you the article when it comes out. But DOJ is not done with enforcement in this area of provider-owned managed care plans. So that's a secret double bonus, double secret probation note on this. So we are, I see we're running close on time, so I don't think we have any time for questions. Apologies for that. We got started a couple minutes late. We're having some trouble with the audio on the platform that we use for this, but I'm glad you're all hearing me. Otherwise, you just spend an hour just watching my lips move. You probably still get CLE credit in most states. So anyway, I appreciate you joining me today. I hope this information was helpful to you and to your organization. As a reminder, this program has been approved for legal education hours. And so we're going to send you a certificate of attendance. And you can, or you can just click on the icon at the bottom of the screen now to report your hours. We're also going to send you tomorrow a recording of the webcast for watching and for sharing. You can rewatch this if you want to. But critically here, be sure to complete our short survey. It is short, it won't take a long time, and we really do use your feedback to plan future programs that are applicable to your business needs. So the more you tell us in the survey, the better the content's going to be. So make sure you do that. We are at the end of the hour. I really do appreciate everyone listening today. This concludes our webinar. We really do appreciate you. Take some time to fill out the survey. But thanks for listening to us today. Take care.